Dear clients and friends, welcome to our TV show, A Little Book of Legal Stories, which is presented by the law firm Linkage and Mind, and I'm the partner of the company, Yulia Dorova. We are the most innovative law firm in Kazakhstan, recognized by many legal and business associations as one of the best and fast-growing firms on the market. Here are just some facts about the company. We have more than 50 due diligence projects within the last 2 years, good government connections which allowed us to receive substantial tax and investment privileges for our clients, sophisticated corporate structuring for finance and tax purposes, participation in the biggest infrastructure projects of the country like satellite construction Kazakhstan 2 and 3, and oil refinery plan in Atirau, its reburnishment. We participated in law drafting work groups for tax code, and we drafted the law on special economic zones. Also, we provide with pro bono services for small and non-for-profit businesses, as well as we try to help in-house lawyers by providing them with free seminars and webinars on various legal issues. Therefore, we are very happy to assist you in any legal matter which you can have regarding Kazakhstan. So far, our firm was very well recognized in London, where we received awards from IFLR, Corporate Intelligence, Global Law, and other renowned legal societies in tax law, public-private partnership, and firm management. Our managing partner was given prestigious nomination as a European Woman in Business Law in 2011, in line with the biggest law firm lawyers like Clifford Chance, Linklaters, and others. So today I'll cover the topic of debt restructuring, in particular intragroup debt relief. The facts of the case are as follows. A head company gave a loan to its subsidiary, and then the head office, here it is A company, assigned the rights over the debt to an affiliated company C. Therefore, we have a creditor C and the borrower B, but the debt influenced the financial reports of A and B. So we were requested to eliminate the debt from these financial reports using the most tax-efficient way. As you may be aware, simple forgiveness of the debt leads to adverse tax consequences. And one more fact is that the loan was interest-free. We need to start with clear understanding what is debt according to the Kazakhstan law. So, civil code states that the debt is an obligation when one person, the debtor, shall be obliged to commit for the benefit of another legal person, the creditor, company C in our example, certain actions, or to abstain from certain actions, and the creditor shall have the right to claim from the debtor the execution of his obligation. So debt is a type of legal obligation. Then let's go further. If we have a properly concluded monetary obligation, how can we terminate it? The Civil Code provides with several options like the execution, granting of release money, offset, novation, forgiveness of the debt, coincidence of the debtor and the creditor in one person, impossibility to execute, the issue of an act by a state body, or liquidation of the legal entity. Not all of the listed options can be applied to our current situation, therefore I emphasized those of them which are valid. They are smart money, novation, forgiveness of the debt, coincidence of the debtor and the creditor in one person. We cannot apply offset as the basis for termination of the monetary obligation in this case, as an offset requires similar claims by nature. So it's possible when creditors and debtors of each other, which is not our case. Okay, an obligation shall be terminated by the coincidence of the debtor and the creditor in one person, according to the Article 367 of the Civil Code. It usually happens during universal legal succession. For example, when a creditor acquires a merger with the debtor. This will lead to obligation for VAT, which is value-added tax, and there is only very remote risk that the tax authorities may impute CIT, which is corporate income tax, on the convenience from the interest-free loan. There are other options to use the coincidence of the debtor and creditor in one person through contracts of guarantee, but I won't cover it here and now. It's very complicated. For simple explanation is a case study. The next reason to terminate an obligation is innovation, which is an agreement of the parties to replace the initial obligation which existed between them by any other, which provides for another item or method of execution, novation. It should be clearly indicated that the initial monetary obligation is terminated and prescribed how a new obligation arises in the case of novation. In particular, you should define new subject, manner, and timing of performance of a new obligation. And I will cover tax consequences in the next slide, because they are the same as for granting the release money. The obligation may be terminated by offering smart money, which is not just payment of the money, but it can be transfer of assets, rendering some works or services instead of execution. The amount, the deadlines, and the procedure for giving the smart money shall be established by the parties. Please note that the granting smart money can be done after obligation is violated. The difference between novation and the smart money is that the last doesn't convert the first obligation into a new one, but it seizes it. So in both cases, as for tax consequences, the creditor will become the buyer of goods, works, or services, so-called customer. Therefore, it can offset the input VAT for purchase. However, the debtor will need to pay VAT and CIT on the sales of these goods, works, or services, so-called output VAT, and the funds transferred under the original loan agreement shall be recognized as an advance payment. Then the cost of goods, works, or services should be equal to the original loan amount, of course. Let's go to the last option, which is forgiveness of debt. It's the situation when the debtor is released to pay back by his creditor, and it's the It's a bad situation because gracious forgiveness of the debt shall be recognized as income of the company B, and it is subject to CAT, corporate income tax. Moreover, company A shall pay VAT on the amount of the loan, and the subsidiary B cannot offset this input VAT due to Article 257 of the tax code. The company A will not be able to take on the cost value of donated assets. So finally, this is just very onerous option from tax point of view. Please note that if you will require some consideration for forgiveness of the debt, it will become either granting smart money or innovation, options described above. Finally, as the conclusion, we can see now that the coincidence of the debtor and the creditor in one person through a universal succession or a contract of guarantee is the most tax efficient option to seize the debt in this situation for interest-free loans inside of a group of companies. And finally, if you have further questions regarding this presentation, please contact us and we will be happy to answer them. It was a very long presentation, so I hope it really helpful for you in case you need this information. Have a nice day.